Welcome to the Truth of the Matter edition. We are coming to you from Biafra Television, London. On 25th of April 2017, Justice Binta Nyako granted Nnamdi Kanu bail on health conditions. Justice Binta Nyako ruled that Nnamdi Kanu must not hold rallies. He must not grant interviews. He must provide 3 sureties in the sum of 100 million naira each. The IPOB leader must deposit his Nigerian passport, deposit his British passport with the court. He must not grant interviews. Don't you think that contradicts Nigerian Constitution? That is 1999 Constitution, Chapter 4, Section 39. Don't you think so?
Of course, everybody knows that when you restrict a free citizen from communicating with the public,
yes,
that is against Nigerian Constitution, which stipulates that every citizen of Nigeria has a right to free speech.
Freedom of expression.
Freedom of expression, and freedom to interact with your people, freedom to express yourself. The fact that in granting Nnamdi Kanu bail, the presiding judge said that he would not be allowed to grant interview or to talk to the press. That means you are restricting him from his fundamental rights. Because in the Nigerian Constitution, it is enshrined that you have the freedom of speech, freedom of expression, to tell the next person what you feel about what is happening around you, be it in politics, be it in the normal everyday life. So, for Binta Nyako to grant Nnamdi Kanu bail and say that you cannot address a rally, and he knows that he's a freedom fighter, he has people he will talk to, so you grant him bail. All along he has been in prison, and you say you are granting him bail to go out from the prison, and in setting him free or giving him bail condition, you say you cannot open your mouth and talk to your people. That is an infringement on his fundamental human right. So that particular section or that particular condition, that particular term of bail contradicts Nigerian Constitution.
Yes.
And as usual, the Nigerian Bar Association, the Nigerian judiciary has always been blind, deaf and dumb in the continuous flouting of the Nigerian Constitution. The Nigerian Bar Association and the judiciary has been blind, so they wouldn't even make a comment. But Nnamdi Kanu has a right to object to this bail condition, even though he has been able to fulfill the bail conditions and is now, standing bail. But he can still fight for this bail terms, because even some learned people, learned members of the society, have condemned the bail condition. They have condemned it in strong terms, because some even call it iron term bail. You give somebody a bail condition, while that same condition you give to him, it completely erodes him with the freedom of his normal freedom of expression. Right to tell the people how he feels. Okay, now he cannot even talk to the people of what his experience in the prison. So it is completely out of order. It is against Nigerian Constitution. So Binta Nyako has flouted Nigerian Constitution by giving such a bail condition, which has not even been given to anybody in Nigeria before.
Thank you, Mr. Ikechukwu. Thank you very much for your contribution. Yes, Justice Binta Nyako, we understand that you don't respect your own constitution. Chapter 4, Section 39 of the 1999 Constitution. You have violated your own law, Justice Binta Nyako. Mr. Kanu, Justice Binta Nyako granted Nnamdi Kanu bail on the condition that Nnamdi Kanu will not be seen in a crowd more than 10 persons, that Nnamdi Kanu must deposit his passport with the court, both Nigerian passport and the British passport. Take a look at 1999 Constitution of Nigeria, Chapter 4, Section 40 and 41. They talk about freedom of movement and the freedom association and the assembly.
Yes.
What do you have to take, Justice Ibetanyako?
Well, Mr. Moderator, I thank you so much for giving me this opportunity to make my point as regards to these bail conditions. This bail that we are talking about is under Nigerian Constitution in section 35, subsection 5, where it specifies the way bails are given. What is the essence of giving bails? Bails are given to the accused person in order for him to attend court proceedings from his home. That is the essence of bail. Now, before I go further, Mr. Moderator, I want to put it very clear. What is a constitution? A constitution is a framework upon which a society or an organization is governed. That is to tell you that the constitution is like a skeleton for a furniture builder. That is what a constitution is all about. Now, this bail, the constitution, and this litigation is centered on the concept of rule of law. The rule of law, as we know it, was propounded and propagated by a British professor of English laws called Professor A.V. Dicey. Professor A.V. Dicey, he stipulates that the constitution of every society must be supreme. That is the supremacy of the constitution. And this supremacy of the constitution brings about what they call checks and balances. Now, having said that, coming to the issue of this bail that has been granted to the leader of the indigenous people of Biafra, albeit conditionally. I stand here to tell our general audience, the world at large, the legal society of the world, that these bail conditions are an effrontery to the rule of law. These stringent bail conditions is completely against the tenets of the rule of law. This conditional bail that was granted to the leader of the indigenous people of Biafra is contrary to the Constitution of Nigeria. Although Nigerian Constitution is fraudulent, but the specifications at the court of law by Justice Bintanyako is contrary to the prescriptions of this Constitution. Because this section 35, subsection 5, that talks about how an accused person should be granted bail, this particular part of the Constitution did not specify for such a punitive and discriminatory stringent conditions to be applied to this case. That is to tell you that Justice Bintanyako is dancing naked in the public. Justice Bintanyako has turned the Federal High Court to a kangaroo court. That is to tell you that what is obtainable now in the Nigerian court, presided over by Justice Bintanyako, is not known to the law. What the judge has done is still doing, is still preparing to do, is playing to the gallery of the executive. That is to tell you that the stringent condition that has been prescribed for the leader of the indigenous people of Biafra is not judicial in nature. It is more or less an executive fiat that has been written down and handed over to the judge to deliver. It is quite draconian. So, Mr. Moderator, there are a lot of issues that we must talk about on this case.
Yes, Mr. Kala, thank you very much. Justice Binta Nyako granted Nnamdi Kanu bail on health conditions.
Yes.
And Nnamdi Kanu had been living in United Kingdom over a decade.
Yes.
And Justice Binta Nyako ordered Nnamdi Kanu to produce his passport or to deposit his passport with the court. What does that mean?
It means that in that kangaroo court, the presiding judge gives bail with the right hand and take it back from the left hand.
Yes, of course.
That is what is happening.
Yeah, correct.
Because that is to tell you that this bail given to our leader, Nnamdi Kanu, in a conditional manner, is in other way a violation of his fundamental human rights. This bail is now presently violating his right under Section 40. It also violates his right under Section 41.
Yes.
So when you look at it generally, you will understand that what you have is no more.
If I may come in there, you will understand that Nnamdi Kanu has been in detention, in prison, for the past 18 months. And the tyrant in power, like you rightly pointed out, vowed that over his dead body will they allow Kanu to go. And now it has become impossible for them to continue holding him down in the prison, bearing in mind with all the whole information and with all the materials available to the court, that they now had no alternative than to grant him bail. Now, the tyrant himself now drafted a kind of bail situation, a kind of bail terms that will continue to imprison Nnamdi Kanu even in his own house. Yes. In other words, he will not be seen in the presence of more than 10 persons. He will not be able to travel abroad, having seized his international passport. Now, his health condition under which he was granted bail, he cannot seek for medical help, medical attention anywhere at all that he wants to go.
Yes.
So, bastardization of the Nigerian constitution and the Nigerian legal system and the Nigerian judiciary is moping, is standing still, and Nigerian judiciary and the Nigerian Bar Association are toothless, and in fact they are inexistent. Nobody talks, nobody says anything when somebody's human right is being violated. But I tell you what, the indigenous people of Biafra has vowed to restore Biafra. I never thought we were going to meet up the bail conditions, but now that the Kanu is standing bail, and we are going to go ahead until Nigeria is disgraced in their own court.
Thank you very much, sir. Yes, thank you very much. Justice Binta Nyako has violated her own law. Justice Binta Nyako, Nnamdi Kanu, the leader of indigenous people of Biafra, his right has been violated by Justice Binta Nyako. Right now, we are going on a short break. When we come back, we shall let you know what we should do right now, because Nnamdi Kanu will not succumb to this kind of bail conditions. Keep watching.
Freedom, freedom is what we want now. Calling the United Nations to set my people free. Calling the League of the Nation to set Biafra free. Lord, no. Calling the Africa.
Welcome back to the Truth of the Matter edition. In this segment of the Truth of the Matter, we are going to know whether the stringent bail conditions given to Nnamdi Kanu will tie him down from leading the indigenous people of Biafra. Mr. Kechukwu, do you think that this kind of bail given to Nnamdi Kanu, the leader of indigenous people of Biafra, can tie him down from leading the indigenous people of Biafra to achieve our goal?
Yes, as a matter of fact, it is very funny and very myopic on the part of the judge Justice Binta Nyako, thinking that Nnamdi Kanu, who has been incarcerated for the past 18 months, and yet the affairs of the indigenous people of Biafra continued unabated, cannot continue to propagate and champion the restoration project now that he is out of the prison. So, we want to let the world know that even though that Nnamdi Kanu has been barred from attending rallies or addressing a press conference, but Nnamdi Kanu has lawyers and has assistants who can carry out his messages to his people. So as a matter of fact, this bare condition of restricting him from addressing a press conference or attending rallies doesn't deter or debar him from actually continue his leadership of the indigenous people of Biafra even under this stringent bail condition, because Nnamdi Kanu is accessible to the internet. Nnamdi Kanu is now accessible to telephone conversations. Nnamdi Kanu can contact and can direct his people, the people of Biafra, from the comfort of his home. As I don't see the bail condition as a deterrent to Nnamdi Kanu's ability to lead his people out of this temple of darkness called Nigeria.
Yes, thank you, Mr. Kechbuwori, sir. Thank you very much.
Thank you so
much for your contribution. Yeah, Mr. Carlo Justice Binta Nyako ruled that Nnamdi Kanu, on the bail conditions, one of them, she ruled that Nnamdi Kanu will not be seen in the midst of more than 10 persons. And as she said that, she also said that as Nnamdi Kanu is giving this bail, trial continues. So do you think, and if you go to court, you will understand that more than 10 persons will be in the court. What do you think? What do you have to tell the public?
Well, this is a very technical aspect of this stringent bail condition, although many people may not see it in that way. I want to take you to what they call the principles of fair hearing.
Okay.
These principles of fair hearing also centers on the rule of law, the aspect of rule of law which is called the substantive rule of law, which tends to guarantee the rights and the freedom or fundamental rights of an individual. That is the essence of substantive rule of law. Now, coming to the question that you asked me, this is very, very sensitive, because I believe this is the area whereby the judge wants to capitalize to bring in secret trial.
Yes, of course.
Why do I say this? I say this because if one of the stringent conditions given to Nnamdi Kanu is that he should not be seen with more than 10 persons, that is to say that he has been stopped from appearing at the court. That is to say, if he appears in the court, there will be more than 10 persons.
Yes.
So, the intention of the trial judge or the judge, the presiding judge, is that on the day of Nnamdi Kanu's trial, there will be no press. There will be no press, and there will be nobody in the court that will exceed that number 10. That is indirectly instituting secret trial, which is completely against the principles of fair hearing. And also, this principle of fair hearing, it gives the accused the opportunity to defend himself in the court. And now, when you introduce secret trial, it is also against the Constitution and also an infringement of the right of the accused person
to fair hearing.
To fair hearing,
yes.
So, what is happening now, many people will not see it. But this particular aspect of this stringent condition is very, very dangerous.
Very, very dangerous.
Because it is this particular one that Buhari and his sister want to use to judge Nnamdi Kanu secretly. Because on the day of his judgment, they will bring in the army, they will bring in the DSS, they will bring in the police to stop anybody from coming there in order not to constitute more than 10 people. So, by so doing, is indirectly
being
trying him in secret.
Thank you very much, Mr. Kala.
Thank you.
Thank you very much. Now, Mr. Ikechukwu, sir, what do you tell the legal team of Nnamdi Kanu?
Definitely, the legal team has a job to do. The legal team has a job to upturn and to impress upon this draconian judge/prosecutor called Vinda Nyako vary her judgment, because that ruling, that bail condition has to be varied because it is completely against human rights and against Nnamdi Kanu's fundamental human right.
Yes,
so the defense counsel of Nnamdi Kanu has a job to do even before the next court hearing of Nnamdi Kanu to appeal to these bail terms, so that Binta Nyako has to vary these particular bail conditions so that Nnamdi Kanu will be entitled to fair hearing.
Fair hearing. Thank you very much, Mr. Ikechukwu. You made your point. Yes, the truth of the matter is here to put it clear to our audience that Justice Binta Nyako gave Nnamdi Kanu, the leader of indigenous people of Biafra, stringent bail conditions. And her aim, based on the contributions here, her aim is to try Nnamdi Kanu in secret. She has violated Nnamdi Kanu's human rights. She has violated Nigerian constitution given to her to interpret. Therefore, the truth of the matter is here to tell the world, to tell the Biafrans, to tell...
And Mr. Moderator, I want to direct my last point to the trial, to the judge, Binta Nyako, because I have made mention of the rule of law here, and also the rule of law provides for what is called generally acceptable principle, that is GAP. This generally acceptable principle means applying the rule of law the way it is applied in other climes. Thank you.
Thank you.
And that also goes to say that by imposing a surety to the tune of 100 million, each of the 3 sureties that is going to bail Nnamdi Kanu is still beyond what has ever happened in the Nigerian judicial system. Why is it so?
Thank you.
Why is Nnamdi Kanu's case so different?
Justice Binta Nyako must revise her ruling on the 25th of April 2017. So as it is now, we have come to the end of this program. Always be with us. Thank you.
Freedom is what we need now. Freedom is what we want now. Freedom is what we need now. Freedom is what we want now. Calling the United Nations to set my people free. Calling the League of the Nation to set Biafra free. Lord no. Calling the African Union, talk about my freedom. I'm calling the four corners of this world to set Biafra free. Lord, for so long